All right, well, welcome to chapter 9 in the first chapter in module number 3, where we begin to evaluate the courts. We have looked at the system as a whole, we've taken a greater in depth look at law enforcement and its specific functions, and now we're going to dive into the next facet of criminal justice and arguably the um, most complex facet of the criminal justice system, and that is the courts. So this week we're going to talk about uh, our court structure and its personnel. We're going to talk about the state court structure, the federal court structure, congestion within the courts. We're going to talk about judges, how they are selected, how they are qualified. We're talking about alternatives to the formal court system. We're going to talk about the decision making process and how judges are influenced. And then we'll get into both the prosecutor and the defense attorney. Courts will be different from one state to the next. However, in large part, they are built around the same concept that exists at the federal level. In other words, they almost mirror each other to a certain extent. At the lowest level in most state courts is what's known as courts of limited jurisdiction. In Kansas, we can see that typically as the magistrate's court. It's still a district court, but it's restricted to hearing cases that are only misdemeanors or hearing only preliminary hearings involving felony cases, and some civil cases, limited action cases, some small claims, civil cases, things like that. Magistrate judges are the ones that preside over this level of court, and in Kansas, they're typically elected and have a jurisdiction that's limited to just the county in which they were elected. We also see specialized courts in the courts of limited jurisdiction, and they're kind of a recent development. They're designed to eliminate the backlog from the big benches and to be able to keep the processes moving forward. But we see things like drug courts or juvenile courts, and their jurisdiction is limited to specific types of defendants for specific types of cases, and they have dedicated goals that are established in statute. In most cases, drug courts, the goal of any case that's brought before a drug court is to help rehabilitate an offender. So the focus there is on getting someone through a drug treatment program successfully so that they're not showing up in the criminal court. Courts of general jurisdiction are broader in nature. They are a state court with jurisdiction primarily over felony offenses. They're organized into districts and are accountable to their state's Supreme Court. Judges who preside over these, at least in Kansas, are elected, but they must be licensed attorneys with at least 5 years of experience before they can seek election to the bench. When we think of the model structure of courts, our text talks about a model structure, but every state really is different. However, almost everyone sees a court of a limited jurisdiction, a general jurisdiction, a court of appeal, and then finally a state Supreme Court. At the federal level, things only get more convoluted and more complex, but the federal court system is established in Article 1, Section 3 of our Constitution. It has jurisdiction solely over federal laws, over treaties that the United States has entered into, admiralty cases, and maritime jurisdiction. So, in other words, anything that's happened on the water that belongs to the federal court. The trial courts at the federal level are U.S. district courts that are set out across the country. There is a U.S. Marshal assigned to every one of these districts, of which there are 94 in the United States. At the next highest level is the United States Court of Appeals, and they preside over circuits. There are several of those across the United States as well, and Kansas is in the 10th Circuit, whose headquarters is actually in Colorado. Finally, the United States Supreme Court is the court of last resort for both state law and federal law. Any cases that are appealed beyond a state Supreme Court go automatically to the United States Supreme Court. And any cases that would move beyond a U.S. Court of Appeals would go to the U.S. Supreme Court, and they have the absolute final say in any matter. Interestingly, before we go on to the next piece, interestingly, federal judges are appointed by the president and then later confirmed by the Senate. And once they survive confirmation, they occupy those seats for life. Court congestion is a constant topic both in the media as well as within professional circles because the wheels of justice turn agonizingly slow. Um, Part of the problem that has related to this is rapidly increasing state populations. That's not an issue for Kansas. The over prosecution of petty crimes. In other words, we get an overzealous prosecutor who's desiring to clean up some aspect of their community and decides to heavily prosecute smaller offenses, or a state legislature that decides to put heavier penalties on specific crimes based on public outcry or public sway. This increases mandatory prison sentences in a lot of cases, and it's designed as a deterrence, but until that deterrence is actually employed, it doesn't really have an impact except for the courts who get bogged down with it. And then, of course, civil litigation. We live in a society today where we can sue just about anyone for anything, and the court's obligated to work through that. The problems that come from that are an overwhelmed court system that means sometimes lost cases or extreme delays in cases. And in the criminal side of the house, the speedy trial issues become a real problem. I can tell you that during COVID, when the courts had predominantly shut down, well, crime did not. Law enforcement stayed just as busy as it ever had. But the court system really wasn't moving. And we were running into a problem where we were going to have some constitutional speedy trial issues come up across the state on some pretty heavy cases. We're talking about some homicides and some other person crimes where the large penalties were at stake. Victims' access to justice was at stake simply because the doors to the courthouse remained firmly shut. So, how does somebody become a judge? Or what does a judge do? Well, the judge is the senior or the principal actor of the courtroom. Nothing moves or happens without the judge's say so when a trial is going on, even in the magistrate courts. Magistrate judges, though, don't have to be law trained. They simply have to be elected to the bench and then later pass a certification test, a bench certification test that's administered by the Kansas Supreme Court. Once they do that, they're good and they're allowed to hear those misdemeanor and limited jurisdiction cases. Most judges have to be a state resident, excuse me, and in most states, judges have to be law trained. Even the limited jurisdiction judges have to be law trained, meaning they have a current law license, and they're somewhere between the ages of 25 and 70 years old. Professionally, judges are typically held in high regard. They're not usually elected if they don't have a decent professional reputation. But the selection of them varies from one state to the next depending upon their system. In Kansas, predominantly judges are elected. The Supreme Court judges are appointed by the governor on the recommendation from the Kansas Bar Association, but the voting public has the elective authority to unseat a Supreme Court justice should they choose to. That's not the case at the federal level. The President of the United States appoints all judges from federal magistrates to Supreme Court justices, and once the Senate has confirmed that person, that is their seat for life, unless they should be impeached. Looking at a limited pool to draw from qualified judges and looking at an overwhelmed court system, many states have adopted judicial alternatives to keep smaller inconvenient cases from entering the courtroom. That's done primarily through three ways. The first is alternative dispute resolution, which just simply means that disputes are settled outside of the courtroom before a case is ever brought. The next is arbitration. We see arbitration a lot in employment law, where an employee who is a member of a union gets terminated or has some kind of discipline given to him by whatever organization that he works for. He or she intends to contest that. Often, arbitration is that first step where a neutral third party can step in, look at the case that the organization has brought, look at the case that the employee or their union has brought, and make a decision about what should occur from there. There's not often a lot of negotiation that happens in arbitration. It's usually a fact-finding mission and then a decision is made. Where negotiation happens is with mediation. We see mediation a lot in family court cases, but particularly divorce cases where there is a property settlement that can't be resolved agreeably. And the court will often assign a mediator to attempt to negotiate an agreeable settlement between both parties so that the court's not forced to take that to trial. When we talk about judicial decision making, we're talking about what it is that influences a judge when they're forced to make a finding of fact or when they're forced to make a determination about what it is that's going on. Studies have shown us that um, principally decision making by judges is influenced by their own personal attitudes, their own ideology, and their own opinions. This is why we have a confirmation process through the U.S. Senate. Ideology heavily influences decisions. Someone who is a conservative thinker and a conservative actor is more likely to rule in a conservative manner, and so on. Sometimes judges are influenced by subconscious bias, as is any person working on a daily basis. It's interesting, our text makes an argument that gender and race can influence judicial decisions. And one of the reasons that I put this picture of Justice Thomas on the screen is that based upon that argument, Justice Thomas would likely be a liberal leaning judge. Instead, he's one of the most conservative judges that we've had, and is one of the reasons he's such a polarizing figure is because folks have anticipated decisions in one direction and seen them actually come in another. The next, and especially at the state level, is reelection. Judges cannot avoid politics, even though they're supposed to remain dissonant. Um, uh, Having their name on the ballot every 4 years certainly has some sort of influence on high profile cases. The next courtroom actor that we're going to talk about, of course, is the prosecutor. Prosecutors can be either appointed or elected. In larger jurisdictions, you typically have a district attorney who is elected, who then appoints assistant prosecutors to work within the system. In small counties like mine, we have a county attorney who is elected and isn't responsible solely for prosecution, but also has a job to act as the county counselor or the legal advisor for county government. Their job in the criminal realm is to determine what the appropriate charges should be before the court after an investigation is complete. In most cases, they have the power to subpoena records, and their job primarily is to represent the interest of the government. The government is their client, not the victim, not certainly not the defendant, and certainly not themselves or even the law enforcement agency. Their job is to solely represent the interests of the government based upon the criminal code. They typically have a distant working relationship with the community. This is done on purpose, and it's designed to allow them to make decisions based solely on a fact pattern and not necessarily on public opinion. Prosecutors have greater discretion than any law enforcement ever thought to have. As we talked in the week before about officers' discretion and how it's influenced, prosecutors carry much more sway than officers do. They have absolute authority in regards to whether to bring a case or not. Even in those cases where officers are told by statute to make an arrest, the prosecutor can still decide not to bring a case. They bring cases either through an indictment where they've presented evidence to a grand jury and let that grand jury make that decision, or they can enter a probable cause statement on their own and file a complaint on their own based on the facts that provided. Their decisions most of the time are impacted by the strength or weakness of the evidence presented in the investigation, any issues related to witnesses. Is that witness reliable? Are they credible? Are they someone that they could put on the stand and not be embarrassed by in front of a jury? Political and public pressure weighs on prosecutors. When big notable cases occur, there is typically a public outcry. There's typically a lot of media attention. And so to say that prosecutors are not influenced by public attention would be just factually a false statement. Sometimes there's process issues. When the court gets drawn down, bogged down, or slowed down, they get into a bind where constitutionally it's the prosecutor's job to make sure that there's no speedy trial issues, and sometimes that's something that they can't afford. Diversion programs have an effect on prosecutors' decisions as well, and diversions are designed to keep people from having a criminal record, but they get supervised for a limited period of time, and they pay a fine to the county attorney's office. That money doesn't go to the state. It typically goes to a pool of funds that the prosecutor has that he or she can use to fund different functions of their office and or to dole out to law enforcement agencies for training, equipment, etc. The bigger that pool is, the better equipment and training they can provide. The next court actor is the defense attorney. And this is going to sound odd coming from a cop, but the defense attorney is arguably as critical to the process as is a judge. Every person has a constitutional right to counsel. And the advantage that the defense attorney has is that their only concern is their client. They don't have to worry about public opinion or sway. They don't have to worry about politics, and they don't have to worry about, to a certain extent, the victims involved in any kind of a case. Their only job is the best interest of their client. Having said that, though, they are still an officer of the court. They're still obligated at the same level of ethics and integrity and honesty that the prosecutor or the judge would have. Finally, when we talk about the right to counsel, in Module 1, we talked about the fact that those defendants that are stuck with a public defender don't always get the best representation as would someone who would have the means or the funds to hire their own counsel. And that's a byproduct of public defenders' offices simply being overworked, or an appointed defendant, an appointed defense lawyer, simply only putting minimal effort because he or she's receiving minimal pay. However, the constitutional right to have counsel with you is absolute. In most cases, the court presumes it's automatically going to occur and work towards finding appropriate counsel for a criminal defendant. Most courts have an indigent defense service, which has a fund that pays those attorneys to defend these clients, but it requires the defendants to fill out an affidavit to essentially prove they don't have the funds to pay for an attorney. Assigned counsel is typically private attorneys who agree to serve as an appointed defense counsel. They're paid at a lower rate, but they're appointed by judges to take cases on. In larger jurisdictions, some counties simply have a public defender's office. They are tax funded, just like the prosecutor is, but again, their sole role is just to defend criminal defendants. The first one of these programs that we ever saw was in Los Angeles way back in 1913. And as is the case, as I've talked about a couple of times now, most public defense offices in these large jurisdictions are understaffed because the pay is not great and they're completely overloaded with cases. As we dive into the court throughout this module, you're going to find some things that may or may not cause you to scratch your head a little bit and may or may not be perplexing to you. Take good notes as you're reading through the book. Highlight anything that you may have questions or concerns about. Feel free to reach out if you need to. This week's discussion post talks about specialized courts simply because they're the newest facet that we've seen in large scale. And I'd like to see your take on what their benefits are and what their drawbacks are. I look forward to your discussion posts. We'll talk again next week.